Hi everyone. In today's class, we are going to discuss about the TP Act, that means the Transfer of the Property Act, 1882. So, when we are talking about the transfer of the property, then we need to understand the what do we understand by the transfer of the property. So, the property transfer means when you are transferring the goods or the property from one person to the another person. Okay. So you may ask me, what kind of the property can be transferred? Okay. So under the Transfer of the Property Act 1882, there is the specifically two kinds of the property that can be transferred. So what are those? The first one is the movable property and the second one is the immovable property. So what do we understand by movable property? The property which is movable in nature. अगर हम हिंदी में बोले तो जिसको हम मूव कर सकते हैं, हम इधर से उधर कर सकते हैं, जिसको हम रिप्लेस कर सकते हैं, उसको बोलते हैं मूवेबल प्रॉपर्टी. द प्रॉपर्टी व्हिच इज नॉन रिप्लेसेबल इन नेचर, जिसको हम रिप्लेस नहीं कर सकते, जो एक जगह पे फिक्स्ड है, जिसका एग्जिस्टेंस पे हम कोई भी इधर उधर नहीं कर सकते, उसको बोलते हैं इमूवेबल प्रॉपर्टी. ओके. मूवेबल प्रॉपर्टी में क्या क्या आता है? जैसे कि हम दुकान जाते हैं, सामान खरीदते हैं, है ना, उसको हम क्या बोलेंगे? मूवेबल प्रॉपर्टी ही बोलेंगे, क्योंकि वहां पे हम जो प्रॉपर्टी है ना, वो एक जगह से खरीदते हैं. दैट कैन बी मूव्ड, दैट कैन बी बॉट, that is easily replaceable in nature, that is called the movable property. The immovable property means जिसको रिप्लेस नहीं किया जा सकता. जैसे कि आपका घर है, आपका जमीन है, कोई पेड़ है, क्या हम उस चीज को यहां से वहां, उसका जो प्लेस है, उसको चेंज कर सकते हैं? मान लो आपका कोई जमीन है, जब आप जमीन को बेचते हो तो क्या आप जमीन का लोकेशन चेंज कर देते हो? क्या आप जमीन को उठा के एक जगह से दूसरे जगह पे रख देते हो? नहीं ना. आप जब घर बेचते हो, जमीन बेचते हो, या फिर कोई फॉर एग्जाम्पल यू आर हैविंग ए गार्डन. ओके. आपके पास एक बहुत बड़ा सा गार्डन है जो कि आप बेच रहे हो विथ ए सर्टेन प्राइस. So these things which you are selling, your land, your home, your garden, these things are non-movable in nature. इसको आप मूव नहीं कर सकते, इसका जगह चेंज नहीं हो सकता. ओके. सो this kind of the property is non-movable in nature. Okay. And due to this non-movability nature of this property is being sold on the paper and pen only. इस प्रॉपर्टी को हम इधर से उधर लेके बेच नहीं सकते. हम प्रॉपर्टी का जो मूवेबिलिटी है, जो प्रॉपर्टी का जो डॉक्यूमेंट है, जो डिटेल्स है, उसी को पेन एंड पेपर पे डिटेल तरीके से लिख के उसी को ही ट्रांसफर करते हैं. when there is the transfer of a land to a particular person, वो क्या होता है? क्या लैंड को उठा के आप दे देते हो? नहीं ना. आप जमीन का जो डिटेल्स है, कितना एकड़ का जमीन है, ओनर कौन है, वो सारा का एक डॉक्यूमेंटेशन होता है. There is the proper procedure is being followed by the pen and paper. Okay. So the immovable property has been transferred by the proper documentation. Whether the movable property is being transferred not through the documentation, but the movable property is being transferred from one party to another party by the shifting of the goods. जैसे कि I am selling a book to you. Okay. So when I am doing the selling of a book to you, what I am doing that I am directly selling it to you. मैं सीधा वो बुक आपके हाथ में दे देती हूँ. You are paying me certain amount of the money, and in return, I am paying you that book to you. Okay. So here there is the transfer of the property or the transfer of the goods. What is the good over here? The good is the book. जो बुक है मेरे पास वही आपका गुड्स है. बुक मेरे से आपके हाथ में चला जाता है. द ओनरशिप ऑफ द बुक transfers from you, me to you. So this is called the transferability of the document. Got it? This is called the transferability of the property, the transferability of the document. Okay. So when we are talking about the transferability of the property or transferability of the document, we need to understand that the property is of two types. One is movable and another is the immovable property. The immovable property is that property which cannot be moved, which cannot be shifted from one place to another, but being sold or being transacted by the pen and paper only. But the movable property can be shifted with the ownership from one person to the another person. Okay. So these two kind of the property can be transferred under the Transfer of the Property Act. So what this act specifically deals about? This act is enacted in the year of 1882 on the date, the first of the 1st of the July 1882. It came into force. Okay. So it has the major intention to deal with the property transfer, the property which is not inheritable in nature, the property which comes by the heritability or the ownership from the uh, from the person to person, just like I am having the inheritance from my forefathers and I am getting the property of them. That doesn't come under the Transfer of the Property Act, that comes under the Inheritance Act. But this is dealt with the property which is not inheritable property. For example, the property related to the sale, the gift, this kind of the property is being dealt over here. Okay. For example, I am gifting you something, or I am giving you something, or you were taking a certain kind of the loan or debt from me, or you are taking a tenancy from me. So these all kind of the rented property, tenancy property, movable property, immovable property, the property by the gift, except the inherited property, deals under this act of the TP Act 1882. Okay. So let's understand the commencement of this act. This act came into existence or came into force in the on the first day of the July 1882. First day of the July 1882. That means this act is enforceable in India before the British, before the independence. That means when the Britishers were staying in India, they have brought this act into existence. And since 1882 to till 2024, this act is still on force and still continuing ahead. Okay. Then let's understand about the extent of the act, to where this act is extended. The first point, this act is extended to all over the India. No doubt. This is the very clear thing. Obviously, this act is extended to all over the India, but except to one state. What is that? That is Punjab. This act is extended to all over the India except Punjab. But when you are looking over the act, it specifically says that it extends to the first instance to the whole of India except the territories which immediately before the 1st November were comprised in Part B states or in the states of the Bombay, Punjab and Delhi. Okay. So except the state of the Bombay, Punjab and Delhi, This act is extended to all over the India. Okay, but we need to understand that this act been extended to Bombay on the 1st January 1893 later on, and it also then extended to Delhi also. But in the Punjab, it is not still fully applicable. For example, section 118 of this act is not applicable in Punjab. But the section 54, 107 and 103 of the act, 54, 107 and 103 of this act is applicable with the specific notification or specific uh, notification of the state government. Okay. So this is about the small introduction about the act. Still, this act is not applicable to Punjab fully. For example, section 118 is not applicable in Punjab, but section 54, 107 and 123 is applicable with certain terms and conditions or by the official notification of the government. And Punjab follows its own specific rules for the transfer of the property. So this act is not fully enforceable in Punjab, but it is enforceable in Delhi and Bombay later on. Okay. So this is about the applicability of the act. Okay. Then it speaks about the repeal of the act, that is not important. Then let's understand about the interpretation clause that is explained under section 3 of the act. Okay. Let us understand what this interpretation clause speaks about. The interpretation clause specifically interprets the specific words or the specific terms of the act. The first part of the interpretation clause explains about the immovable property. Immovable property means the property which cannot be moved, which cannot be shifted from one place to another. What are those property? It includes the standing timber, growing crops or grass. The standing timber, as like we already know, timber, we all know na, the timber, standing timber, growing crops, जैसे कि as I was just telling few time back, the land, when you are doing the selling or the buying of the land, are you capable to just shift the land from one place to another? No. यहाँ पे जो जमीन होता है ना, जमीन पे जब मतलब आपका क्रॉप आता है, अब जमीन पे जब देर इज द कल्टीवेशन प्रोसेस ऑन द लैंड, द ग्रोइंग crops in the land is called as the immovable property. But when the crop has been disconnected from the land, जब अच्छे से क्रॉप हो जाता है, जब उसी को जमीन से अलग कर लिया जाता है, then it became a movable property. Until and unless it is attached to the earth, attached to the land, it is considered as the immovable property. Next, grass. Grass, we all know what is grass. So when we're talking about the grass as far as it is attached to the land, attached on the earth, it is immovable, and the moment it is disconnected or it is cut off from the earth, it became a movable property. Got it? So this is the specific example of the movable property we have already discussed. Then the next point, the instrument means the non-testamentary instrument, and I have already told you this act doesn't deals with any testamentary instruments. Testamentary means which is inherited from forefather, from forefather to my father, father to me. This is called the inheritance, the testamentary inheritance. So the instrument which is not dealing with the testamentary inheritance, or the instrument which is the non-testamentary instrument, is called the instrument over here. Okay. The instrument, remember it, what is its nature? It is not non-inheritance. It is non-inheritatory or it is testamentary instrument in nature. Okay. The next point, attested. Okay. So when we're talking about the attested, this is a little complicated. Let's understand this. So what do you mean by the attested? Okay. When we are talking about the attestation of a specific instrument, for example, there is the transfer of a specific instrument from one person to another, and the transfer process needs the attestation of minimum two witnesses or more than two witnesses. Okay, so what is its nature? Attested in relation to an instrument means and shall be deemed always to have meant attested by two or more witnesses, each of whom had seen the executant sign or affix his mark or instrument, or had seen some other person sign the instrument in the presence and by the direction of the executant. Okay, so what does it mean? The first person who is a witness. The witness is the person who has witnessed everything, who is the present at the particular place, or even if that person is not present at the place, the person is aware about the fact what is happening during the process of the attestation. So when we are talking about the attestation means the person, when the property is being attested by one person, there should be the presence of minimum two witnesses or more than two witnesses over there. Okay, so you may ask me, like, what do you understand by witness? A witness is a person who is present at the specific location, who aware about the fact even if the person is not present at the specific place, he is directly involved with the process. He is directly aware about the process and he know exactly what is happening over there. That person is called as a witness. Okay. The witness is a person who is, the attestation must be the thing or the property which is being attested. It must be done by two or more witnesses with the executant. Obviously, when there is the transfer of the property, it must be signed, and it must be officially signed and affixed by the executant itself. No doubt, yes, we all know that the executant means the person who is doing the execution of the property, or the person who is executing the goods, executing the deal, executing the agreement. Okay, that is called the execution. So the sign and the affix of the executant is most important part in a contract, that we already know it. Okay, so when there is the execution of the property, there must be the presence of minimum two or more than two witnesses over the place. So when we are talking about the witnesses, so what is the nature of the witness? How the witness actually works? So when a person is called to be witness, when the person has seen the executant sign and affix his mark the instrument. For example, when there is the process of attestation is going on, the witness is present over there. The witness is seeing that yes, here is the executant, he's standing over here, he is signing the instrument, he is affixing his mark in the instrument. This is all happening in front of the eye of the witness. The witness is actually eyewitnessing or executing or involved in the all this procedure, and he is actually seeing everything and anything in front of his eyes. He's aware about the fact is this person is standing over there, this person is exactly executing the deed, this person is affixing his signature or implying his marks over the instrument. This is happening in front of the eye of the witness. Got it? That is called the sign of the executant and affix in front of the witness. If the executant is himself unable to do it, for example, the executant is physically disabled or mentally disabled person, but with the consent of the executant, Any other person is doing it with the consent of the executant and with the presence of the executant. And that is being seen by whom? By the witness. So, in these circumstances, when the witness, the more than two witnesses, or the two witnesses, they are exactly seeing the process, the affix of the signature, the all things they are seeing in front of their eyes. The first point. The second point, or any other person except the executant if doing this process, then the person who is doing all this process of the execution, he is doing this with the instruction and with the presence of the executant. This is seen by the witness. Okay. Then the second thing, the second part of this, it speaks about when the person or the witness is not present at the particular place. But what is happening? He has received the personal acknowledgement of his signature or mark from the executant that he has done the instrumental deed. For example, I am the witness of an attestation process, and I am unavailable at the specific place to eyewitness all these possibilities or all these procedures. So when I am unavailable to see all these things, what is then still I can become a witness. How? If the executant who is doing this execution process is sending me the personal acknowledgement of its signature or mark of that specific instrument, or any other person except the executant if he has done this process with the consent of the executant, then that person is sending the instrument or sign to me with the personal attestation or with the personal signature. Okay. So in all this process, when the witness is either receiving the personal attestation from the executant or by himself present at the specific place and seeing the execution process, then when there is the presence of more than two witnesses and they are being the party to the execution process, either they may present physically or they are receiving the copy of the execution or which is personally attested by the executant or his representative, then in that specific place the instrument is called to be attested. Remember it, to call a process of the attestation to be completed, there must be the presence of the executant, the person to whom the execution is done, and the minimum presence of the two witnesses. Got it? So this is explained under section 2, which section 3, which speaks about the interpretation clause, and it explained under the provision of the attestation. Okay. So next, the it speaks about the registered. The registered means the property or the instrument which is registered any part of the territories to which this act extends under the law for the time being in force regulating the registration of the documents. Okay. So registered means when any kind of the property or any kind of the instrument is being registered through the official law and order, and official procedure itself, and it is being done by the party who is doing the process itself. That means if there is the proper procedure of the registration is being done by the party or by the parties, then it is the property or the instrument which is done by the process of the registration is called to be registered. Okay. Then the next point, it speaks about the attached to the earth. What does it mean? What does it interpretation exactly examines. Attached to earth means which is rooted in the earth, as in the case of the trees and shrubs. Okay. So when there is a tree, you see. Okay, you see there is a tree over there. The tree is attested or attached it's to the earth itself. The root of the tree is inside the land, inside the uh, earth itself. So that property is called to be attested or attached to the earth, जिसका जमीन से लगा हुआ रहता है, जो जमीन से अलग नहीं होता है, उसका जो रूट होता है ना, जो मतलब पेड़ का जो रूट होता है ना, वो कहाँ पे होता है? वो जमीन के अंदर ही तो होता है ना, वो जमीन के बाहर नहीं होता है. सो द रूट ऑफ द लैंड इज रूट ऑफ द tree is actually inside the earth. Got it? The second, the shrubs. Shrubs we all know. So the root of the shrub is also inside the earth only. But when the shrub or tree is detached, is being cut off, जब उसी को हम कट कर देते हैं, you tell me, is it a movable property or immovable property? Is it attached to earth anymore after being cut off? The answer is no. Once the tree or the shrub has been cut off from the land, it is not attached to earth anymore. As far as it is rooted in the earth, this is called attached to earth. The second point, embedded in the earth, as in case of the walls or buildings. When there is a property which is embedded in the earth, that means जब ये जमीन से लग के रहता है, इट इज नॉट रूटेड इन द अर्थ, बट जमीन के अंदर इसी का जो होता है ना, उसका रूट स्ट्रांगली बेस रहता है. जैसे कि हम जब घर बना रहे हैं, हम कैसे करते हैं? पहले हम आर्थिंग देते हैं, घर का खुदाई करते हैं, उस नीचे जमीन के नीचे हमारा घर का एक बेस बनाया जाता है, उसी के ऊपर ही हम पूरा घर खड़ा करते हैं कि नहीं? सो दिस वॉल्स एंड द बिल्डिंग्स, आप कोई मतलब वॉल खड़ा कर रहे हो, कोई बिल्डिंग बना रहे हो, दिस इज ऑब्वियसली एम्बेडेड टू द अर्थ. इसी का जो बेस है ना, वो अर्थ से अलग नहीं होता. दिस इज अटैच्ड और एम्बेडेड टू द अर्थ. तीसरा, अटैच्ड टू अर्थ, सो एम्बेडेड फॉर द परमानेंट बेनिफिशियल एंजॉयमेंट ऑफ दैट व्हिच इज अटैच्ड. Anything which is done for the permanent beneficiary. For example, there is a small house which has been built for the permanent benefits of the students for a long term year. For example, there is a study room has been prepared in a village for the study purpose of the children. Okay, so this has been made for the permanent beneficial enjoyment of the students. Okay, and it is embedded to the earth, and that to which it is attached, it is attached to the earth. Got it? So in all these kind of the circumstances, this is called attached to the earth. In short, when we are talking about the attached to earth, it means it is actually attached to the earth, it is actually embedded to the earth, and it is inseparable from the earth itself. Okay, then actionable claim. So what does we understand by the actionable claim? The actionable claim means a specific kind of the claim of the property. Okay, so an actionable claim is the right to claim a debt or benefit in a movable property. Okay, movable property, what is movable property? We all know the property which is not permanently attached to the land and which can be moved from one place to another. The actionable claim is the right to claim a debt or benefit of a movable property, the property which is not permanently attached to the ground like furniture, and the claimant does not currently have their possession either physically or indirectly, and in that circumstances, okay, the claim can be recognized in a civil court as a legitimate basis for legal action whether the debt or benefit is currently due and expected to be due in future, conditional or even uncertain. However, debt secured by a mortgage on immovable property like a house or movable property are not considered as the actionable claims. Okay. So what does it, according to the section it speaks, actionable claim means a claim to any debt or other than a debt secured by the mortgage of immovable property or by hypothecation or place of the movable property. Okay. So actionable claim is specifically the claim over a specific debt amount. For example, you have taken a debt amount of 15,000 rupees from me and you are claiming the debt benefit on behalf of the me. You are telling me that, ma'am, you have taken the 15,000 of the me, 15,000 from the me with the interest of 5,000 rupees per month. So you have to repay me that specific amount. That is called the claim, or that is called the actionable claim for a specific debt. Okay. And when the debt is not secured by immovable property, but it is secured by the immovable property, hypothecation or the place of the movable property. If the debt is secured by the immovable property, it is called the mortgage. That we will understand later on. Okay. If the debt is secured by the immovable property, it is called the mortgage. If the debt is protected by the hypothecation or place of the movable property, it is called the actionable claim. So what do we understand by the hypothecation? Hypothecation is applicable to the secure loans, and it is the act of placing an asset as a collateral without transferring the ownership to the uh, ownership. That means when an asset is placed at the collateral to secure a loan, the asset owner doesn't give the title, possession or the ownership, but the income generated by the asset is being transferred through the hypothecation. That means, for example, there is the how to make you understand. Uh, for example, I'm having a specific kind of the furniture and I am getting benefit from that specific furniture and I am using that furniture. Okay. And I have taken the amount of 15,000 of the rupees of the debt from you and I'm unable to pay you that specific debt. So I am securing the debt by providing you that furniture for a certain period of the time that the furniture is itself a movable property. I'm transferring you that furniture. I'm saying to you that yes, keep this, use this. Any kind of the profit which will be aroused from this furniture or from this specific instrument, you can take the benefit for a specific time period of 2 years. 2 साल तक आप इस फर्नीचर को अपने हिसाब से यूज करो, उसी से आपको जो भी बेनिफिट मिलेगा उसको आप रख लो. And instead of paying up the debt, I am securing my debt by giving you a movable property or movable instrument, and I am transferring the benefit which is arised by the instrument to you. Okay. So when there is the hypothecation of the place or of the movable property and the beneficial interest of the movable property is not in the possession of the real owner, here the ownership is not specifically transferred, but the beneficiary possession has been transferred. That means the person has not transferred the proper ownership in details, but the person has transferred all the beneficiary interest from himself or herself to the other person. So in that case, this kind of the claim is called the actionable claim. And when the civil court is recognizing this kind of the relief, okay, and the court may order for, so this kind of the benefits occurring from this claim is called the actionable claim, okay, and the actionable claim has been transferred by the civil court, okay, and the civil court can transfer this actionable claim from one person to the another person, okay. So one more thing over here, when the civil court is transferring this claim, the claim of the grounds of the claim, it must be sure that the beneficial interest must be existent, accruing, conditional, or contingent. So what does it mean? The benefit must be the first point, it is existent in nature. That means the benefit whatever arising from the property, it must be in existence. It must have a proper validation or existence for the of the transferability. The second thing, it is accruing. Accruing means it is increasing. For example, there is a debt, I have paid you the amount of the 5,000 of the rupees, and with force of time, when I am unable to pay you the specific debt amount, the debt amount is increasing. For example, in the first month, you have to pay the interest of 5%, then it is increasing to 10%, then it is increasing to 15%. Though it is accruing, it is increasing in nature. Okay. The third point, it is conditional or contingent. Conditional means it is certain, it is associated with certain conditions associated to it. And the last point, it is contingent in nature. It is non-conditional in nature. It is not associated with any kind of the conditions or proper rules or proper regulations therein. Okay. So in all these circumstances, when there is the claim of a debt of a specific property and the claim is being secured by the benefit acquiring from a immovable property, that is called the from a movable property, that is called the actionable claim. So if there is the benefit acquiring from a immovable property, that is called the mortgage. But if there is the debt which is secured by the movable property and its benefits, it is called the actionable claim. Okay. Then the next point and the most important point, what does it mean? It speaks about the notice. So when the person is called to have the notice of the fact, okay. So a person is to be called the notice of the fact when when the person is supposed to know about it. The person is actually have the knowledge about it. And the second point, they would have known it if they had not deliberately avoided investigating or ग्रस्त और been negligent to it. थोड़ा अच्छे से इसी को समझते हैं. जब मैं बोलती हूँ कि notice of the fact about something, so what does it specifically means? Notice of the fact means मेरे को उस चीज के बारे में सही ढंग से पता है. I actually know about it. I know about the fact what is happening. Okay. The person has the whole awareness about the fact, whole knowledge about the fact. And the second point, if I would have done the proper investigation, or I would have not been negligent, I would have been aware about the fact. That means, for example, I am buying a land, okay? So when I am buying a land, after buying of the land, I got to know that the possession of the land from whom I have bought, that is a fraudulent possession, and the person who has sold me the land is not the real owner of the land. So here, when it is said that the person has the notice of the fact. That means if I am the real owner over here, if I am the person who is buying the land, if I would have tried a little bit, मैं अगर थोड़ा सा भी कोशिश करता, if I would have not negligent about the buying of the land, then I would have get to know the original ownership of the land. अगर मैं किसी से भी थोड़ा बहुत पूछता, किसी से भी थोड़ा बहुत बातचीत भी करता ना, तो मेरे को पता चल जाता that the person who is selling me the land is not the real owner of the land. But यहाँ पे I became negligent. I trusted the person who is selling me the land and I bought the land. Okay. So here, this is the action by me. This is not the accurate action. This is not the proper action itself. I am myself negligent to the buying of the land because this indicates my negligence to investigate the fact. I didn't do the proper investigation to the fact. I didn't be aware to know about the fact, and I didn't put my interest to know the actual fact about the land and what is happening over there. If I would have put my effort to know the proper reasonableness, the validity, the legality, the ownership of the land, then I would have get the idea the person who is selling me the land is not the accurate owner of the land. So here, even if I I am innocent over here, I don't know the person who is selling me. The person has not identified the fraud itself. But here, due to my negligence, it will be considered that I had the notice of the fact over here because I became negligent to the investigation process. So, notice of the fact is restricted to the two conditions. Either the person who is doing the agreement or who is doing the contract or who is doing the buying or selling the property is completely aware about the fact, the point number one. Or the second point, the person would have known the fact if he would do the proper investigation into it. But due to the own negligence, he is avoiding it or he has not done it. Got it? So this is called the notice of the fact. Then comes the explanation, which we are going to discuss in the next class. So today's class we have discussed the most important section about the actionable claim, the interpretation clause, the extension of this act and all these provisions. Rest, the explanation portion we are going to discuss in the next class itself. So we can wrap the class over here guys. Thank you so much and take care. Bye bye.